Welcome everybody to Wolfsdorf Rosenthal WR self-sponsored green card webinar. There's been a lot of interest in this, especially since the visa bulletin was opened, and we're going to have a little bit about that. But I really wanted to put it together with a self-sponsored green card. A lot of people, for instance, have, unfortunately lost jobs. Some want to change jobs. And self-sponsored is a very, very good way to, to get to the promised land of a green card. Without the need for sponsors. Some sponsors can't sponsor anymore or change their policies. So it's a very apropos topic for our current times, especially in this pandemic. I always start these webinars with a disclaimer. We are lawyers, we do need to have a disclaimer. And whatever you hear today is not going to be considered legal advice for your own case. Unfortunately, or fortunately, immigration law is very, very complex, and it's critical for every person to discuss their own cases with an immigration lawyer specifically, because while this is good for general information, it's going to give you a flavor of the topics of the topic. It's also going to give you the wherewithal to know how to deal with an application in general. But it's really complicated enough. Just like you wouldn't do surgery based on a webinar, you should certainly not practice complex immigration law surgery with a webinar either. Just a little bit about us, not too much about us, but a little bit about us. We're a Wolfsdorf Rosenthal WR. We're a full service immigration law firm. We have offices throughout the United States. I don't want to focus too much on us. I want to focus a lot on the topic. So let's move on. Some of our awards: best lawyers, chambers. A little bit about me, which is even less important. I'm one of the partners at Wolfsdorf Rosenthal. I've been doing this for about 20 years and very much focusing on self-sponsored green cards. My contact is below. Any questions? There will be time for questions at the end, but certainly if there are any questions that come up that are not dealt with, in the presentation or in the question session, feel free to contact me. I'm happy to answer any questions that you may have. Then just a plug for our adjustment of status webinar. That's tomorrow, 10 a.m. PDT, 1 p.m. EDT. The flavor of the day is really the visa bulletin and adjustment of status, how that links with the visa bulletin, as many of you know, and we're going to see a little bit of that today. As you all know, the visa bulletin has been advanced significantly, and that's going to be an in-depth discussion with our managing partner, Bernie Wolfsdorf, tomorrow to go into the nitty-gritty, the details based on the visa bulletin and how it affects cases that are filed, new cases, etc. While we will touch on this today, it really will be an in-depth dealing with this specific issue tomorrow, and I encourage everybody to log on and listen to that. I think it's going to be very, very useful and helpful to cases that you may have filed. Okay, so let's get into the cases of self-sponsored green cards. So just generally with green cards, there are always two places or two types of two components of the green card process, and I always start with this. I think it's a good place to start. The first is called an immigrant visa, and that is what we call your basis for immigration. Why does America want you? And we're going to see a couple of bases for immigration in the next slide or so. But why does America want you is the basis for immigration, why you're going to immigrate to the United States. And then the second part is what we call the adjustment of status, and that's what we call your actual immigration, which means the technical move from usually a temporary visa status, could be an H-1B, an F-1, a J-1, or somebody could even be outside of the United States, but it's the actual immigration where you become a permanent resident. And this is, we're going to see where we're going to see quotas, where quotas and backlogs come in at this stage. When I talk about backlogs, I'm not talking about the backlogs that it takes for immigration to process or to adjudicate an application. Those are what we call normal backlogs. They can be very, very slow. They can be extremely slow. But the quota backlogs I'm talking about are backlogs based on quotas. For every green card category, there is a quota for how many immigration can grant in a specific year in that category. That's number one. And number two, there's a there is a quota for how many those born in a specific country can can benefit from one of the quotas. So certain countries, India and China, we see a lot of visa applications. They exceed their quotas quite almost all the time. So because of that, they're always even behind those of non-Indian and Chinese applications. And quotas always go by country of birth, not necessarily country of citizenship. So somebody, for instance, that's born in India but has Canadian citizenship, they will be considered Indian based on the quotas, because that is because quotas are based on country of birth. Okay, so let's look at some of the bases of immigration that we're going to discuss. Employment-based, EB, if you hear EB, EB1, EB2, a lot of you have heard that term. It refers to employment-based. And even self-sponsored applications are still considered employment-based, an employment-based category, even though technically you don't need an employer to sponsor you. So the two that I'm going to focus most on today are going to be National Interest Waiver, NIW in the vernacular, Alien of Extraordinary Ability, which is sometimes referred to as EB1, EB1A, EB11. Those are the two main ones. And then we're going to touch a little bit on investment green cards, EB5, family-based, and green card lottery. But certainly, those could be their own webinar, on their own. So the two main ones I'm going to discuss are National Interest Waiver and Alien of Extraordinary Ability, and touch on the other ones in the slide. Okay, so we spoke a little bit about your basis for immigration and your actual immigration. So step 1 and step 2. Immigrant visa is another term for your basis of immigration. In the family-based arena, it's called an I-130 petition. You'll hear of an I-130 basis for immigration. In the employment-based, you can hear an I-140. These are the names of the forms for employment-based basis for immigration. And then for the adjustment of status, you look at form I-45 is the usual one. So in terms of adjustment of status, and well, at least the step 1 and the step 2, in certain categories and for certain people, you can file both of them together, which is counterintuitive, and especially with the visa bulletin this month. I-140s and I-45s can actually be filed together for just about everybody, as long as you're not Indian or Chinese. Even though they've advanced quite a lot, everybody else can file these together, which takes a lot of time off the application. The premium processing is an expedite service of immigration, which many have heard of. It adjudicates the case in 15 days. It's going to be now 15 business days, up from 15 calendar days. It does apply for the EB1 category, but certain categories like the National Interest Waiver, the NIW, are exempt, which means you're looking around about 9 to 12 months without that premium processing. For the I-45 adjustment of status, the major benefit of filing is that you get an employment authorization document with this filing. You don't get it with the basis for immigration, the I-140 or the I-130, unless you file them concurrently. But the employment authorization document in these times is very, very useful. It allows a person to work beyond their H-1B or whatever visa they may have. It allows them in certain cases, especially in self-sponsored categories, which is one of the major importance, the critical nature of employment-based of self-sponsored application is you don't need an employer. You can, as long as you're working in your field, you can continue to work even if your work visa, such as an H-1B, is terminated. Advanced paroles are travel documents, got nothing to do with prison. Advanced paroles are travel documents, which are very, very useful. Unlike certain H-1Bs, F-1s, J-1s, you do not have to go to the consulates if you have one of these. So especially in our current times of the pandemic, when many consulates are closed, very hard to get appointments are canceled, et cetera, et cetera. Having an advanced parole travel document is an essential travel tool for almost everyone. And then there's no premium processing for adjustment of status. 9 to 12 months is kind of the regular time at the moment. Things are a little slow in terms of getting appointments. Some appointments, some interviews are waived. You do have to go through an interview under the current processes, but many of them are waived at the moment during COVID. One sec. Okay, so this is the famous visa bulletin that that everybody's talking about. This is the dates for filing chart, which is when those who have a basis for immigration on I-140, usually on I-130, or this is an employment based on I-140 based immigration petition filed or approved, then they can go into the I-45 stage if they meet one of the criteria before. So if you see a C, that means current, which means that however long it takes for the application, there are no extra backlogs based on quotas. So you see, for anybody born in India and China, except for those in India and China, all of those are current, which means you can go ahead, which means it's a very unique opportunity for everybody at the moment to get adjustment of status filed, simply because there are going to be so many applications in the next month. It's hard to know what's going to happen in the coming months after after October, whether there's going to be significant backlogs just because of the glut that's going to happen in the next month. So everyone's, if they can, is certainly encouraged to try file it as soon as possible. If you look at China and India, the dates are very much up by previous visa bulletins. So a lot of Chinese and Indians, even though they're not current, they certainly can file applications if they've had cases pending for a while. If you look at one anomaly, well, the anomaly for China and India, if you look, strangely, EB3 is more current than EB3 for China and India are more current than EB2, which means there's a unique opportunity for certain people to downgrade. If they have EB2s filed, they can certainly downgrade to EB3. These only applies to those in the perm sponsored applications. So this is an application. These are applications that a lot of people are filing, and this is going to be the subject of the webinar tomorrow. Okay, so let's jump into the national interest waiver, the NIW. So the NIW is one of my favorite categories. It's certainly not, as we'll see, it's not as high of a standard as the EB1. And certainly, if you're not born in China and India, it's certainly a very important green card tool. It's a very realizable, realistic green card category for many people. And there are various types of national interest waivers. The first type, and the most common one, is on national interest waivers that deal with researchers. And just because most national interest waivers tend to be for researchers, I'm going to focus on that, but they don't have to be for researchers. The criteria, as we will see, can apply to anyone. We could apply to business as well, but most business national interest waivers tend to be more customized in terms of what kind of documents you need, how you're going to prove it, how do you prove what you're doing is in national interest. So in those cases, if anybody has wants to try or wants to discuss a national interest waiver with me in the business field, they should do that, by the email that I previously presented. In terms of the preliminary test, okay, advanced degree, you have to, for national interest waiver, you have to have an advanced degree, which means a master's degree or a bachelor's degree plus 5 years of post-baccalaureate experience. So either of those is equal to advanced degree for immigration terms. If you don't have either a bachelor's degree plus 5 years of experience or a master's degree, then you have an alternative way to get into the national interest waiver by showing exceptional ability. Now, exceptional ability is a much lower standard than we're going to see what's required for extraordinary abilities. So immigration uses these various terms, and there are nuances in these terms. So exceptional ability is slightly or quite a bit less than extraordinary ability. The national claim outstanding ability is even somewhere in the middle. But for exceptional ability, essentially you have to show that you have a diploma, you have 10 years of experience, you have some contributions to the field, and that you're somewhat above those ordinary ordinary practitioners in your field. So the national interest of the preliminary test, the national interest test is a 3-prong test that was created by the Danosaur case, and for each national interest, and Waive. And remember here, we're dealing with basis for immigration. This is your basis for immigration. So what the first requirement is that proposed endeavor, whatever you're going to do, could be you're a researcher, what your research is. It could be you're a CEO of a plumbing company, which is a case that I just recently got approved. So you have to show whatever you're going to do, your proposed endeavor has substantial merit. Most of the things that you're doing have substantial merit, so it's quite an easy test, and has national importance. So it's some sort of national flavor to it. It doesn't have to be totally national. For instance, my plumbing company, it didn't have to show that, they had plumbing companies all over the United States. But they did have to show that, that they had some national importance. It was a very big plumbing company, and certainly, it was in a depressed area. And during the pandemic, we have a lot of depressed areas. It provided a lot of jobs. So it had national importance in that, in that way. So that's number one. The proposed endeavor must have substantial merit and national importance. Number two, the beneficiary is well positioned to advance the proposed endeavor. In other words, what are you doing? How do you advance this important endeavor that you're doing? So, for instance, if you're a researcher, you're going to be showing that you've had publications and impact, etc. It could be your degree, it could be special skills, it could be the CEO of a big company, for instance. Who's advancing, the national interest. If we said that was creating employment for employees, and then the third requirement is kind of a balancing. This is on balance, it would be beneficial to waive the job offer requirement and the labor certification. So the labor certification is really a process where most employment-based green cards fall into. Essentially, employer recruits for the position and makes sure no US workers have the minimum requirements for the position. So we have to show that the minimum requirements is not a good way for somebody who has national interest in mind. So for instance, we want for instance, if you have a scientist who's doing critical scientific work, what we want to do is we want to show that we want the best scientist for the job, not the one with the minimum requirements, which what the labor certification deals with. Okay, so as we said, just dealing with these three prongs a little bit deeper, most scientific research is considered to have substantial merit and national importance, and other endeavors as well. And one of the ways you can look at it is, does the federal government, do they fund it? Is it the type of research that they would fund? Doesn't mean they're actually funding your research. Obviously, if they're funding your research, then you have a very strong case that your research or your work is of national importance. But if it's something that the government, the type of work that that the government funds, and that would also be, show that your work is in the national interest and it would satisfy that prong. Similarly, the government funds a lot of things, not only scientific research. It funds the arts and just very, very different things, museums and a lot of different things that are national importance. For instance, we just really did a case for somebody who runs an organization that deals with human rights, and showing that human rights is in the national interest was something that the government accepted as a type of endeavor that is a substantial merit and national importance. The second part of whether the person is well positioned to advance the endeavor. So, if you're dealing with research, you're dealing with research that's widely used. They look at your impact on the field. It could be your citations. It could be press. It could be how you how you've published. Are they top journals, etc. And we'll go through that in more detail. Special skills. Sometimes, a person doesn't have a lot of publications, etc., but has a lot of special skills that just cannot be found in the market, or they can be found in the market, but they're very expensive to train somebody, etc. So these are skills that that can make up for low publication rates and things like that in the research field. And then evidence that a beneficiary will continue in his or her field. Even though these are not, these are self-sponsored, you don't need an employer, you do have to show that, you do have a plan is a way for you to continue your research. So if you're a postdoc or a graduate student, these are considered temporary positions. You should have a plan. You should have something to show what you're going to do once the postdoc or once the PhD, for instance, is completed. And then that final point which we discussed on balance, it's beneficial to waive the job offer and the labor certification. That's, as we said, the normal process of immigration, where the employer recruits for the position and makes sure no U.S. workers are qualified. So obviously America has an interest in protecting American workers, and that is going to be balanced against the national interest that the foreign national is going to bring with this application. So they're going to look at those two together and going to weigh those two together. Most times the way we handle this is saying that the labor certification generally deals with minimum requirements. In other words, if there's a scientist with the minimum requirements, but not the best requirements, that could end the labor certification. But with the national interest waiver, we want the best scientists and not just the minimally qualified scientists to deal with our national interest. Okay, so it's a lower standard than the EB1. We're going to see the EB1 in a little bit. EB1, as we say, is an alien of extraordinary ability, very, very high standard. And this is a much lower standard. It's about working in the U.S. national interest and being in a position to advance that national interest in a way that immigration feels that it's worthwhile to grant you this category. Okay, so in terms of evidence, and for researchers, it's very, very similar, the type of evidence for an NIW as opposed to an EB1A. It's the same type of evidence, but it's actually very different standards. So same type of evidence, different standard. So the publications, if you're dealing with researchers, publications, distinguished nature of the journal. If it's a very important journal, that helps. They look at impact factor, ranking by impact factor, etc. If you're first author, that's important. If you're one of a large number of co-authors, then they will look where you are. Some, for instance, in atmospheric science and space sciences, you can have hundreds of people on a collaboration. You're one person in that collaboration. So it's better if you stand out. But the fact that you're a co-author does not, disqualify you from a national interest waiver. These things are much more attuned when it comes to the EB1A, where they're much more strict on these. The most important thing when it comes to a national interest waiver for a researcher is Google Scholar. That's immigration realizes they have somewhat of an objective way to look at the impact of a researcher's work. So citations is very, very important. For national interest waiver, it's much lower than the EB1A. You're probably looking only around about 50 citations for a very strong national interest waiver case. And then just the different types of extra evidence. If you review for journals, that's considered good. Other service as well, serving on committees, especially if the organization is national, international, organizing conferences, especially if it's national or international. Generally, international is fine for a national interest waiver, even though it's national is not international. It's kind of assumed that national, if something has international flavor, it certainly has national flavor as well. And then just when it comes to reviewing, you should be reviewing in your own name and not in the name of your PI. If you're ghosting your PI, that's not going to help us in proving that you did it. Press releases, signed daily is a very popular one, but there are different types of other media coverage. So if you have media coverage, that always helps. It shows that that people are covering, that the media is covering your work. Grants are important, especially if you're listed on the grant. For a national interest waiver, it doesn't really matter what you listed on. It's important, even if you're PhD postdoc, but certainly if you're much higher, designated co-PI or PI is even better. Awards awards help as well. They can be travel, student awards, poster recognitions. For national interest waiver, all these are very, very cogent evidence. As we're going to see in the EB1A, it's less cogent for that. Presentation conference, patents. So patents that are approved are much more value of pending patents. Provisional patents are somewhere in the middle. You could use proof that companies are using your research or any technique that you have. It could be a contract letter, something to show that, you know, whatever you've done, whatever endeavor you're doing, you know, and is something that, you know, is in the national interest by the fact that, you know, companies are using it. And then reference letters are important. We want to get the best experts that are possible. Generally, we want what we call independent letters. They should be letters from people that are not close, from an institution closely aligned to you. It shouldn't be your supervisor, shouldn't be your co-authors. 4 or 5 letters is usually enough. And just back to the independence of the letters, it's just, you know, if you have 1 or 2 letters from supervisors, or if the supervisors are not showing, you know, they're not attesting to your abilities, but really showing what you're doing. In other words, that first prong of what the endeavor is, that would be sufficient. But they shouldn't be showing your abilities and commenting on your contributions to the field, because in immigration's views, they are biased. Research statement, that's really so we can explain to immigration what exactly you do, especially if you're a scientist. Sometimes it's very, very difficult for immigration to understand what you do, and it's important to put that into layman's terms for immigration. Okay, so NIWs do have a prospective element. Basically, they're saying, what are you going to do in the future? What is your future endeavor? So the question is, again, why do we focus on past achievements? Generally, past achievements are the best way to show future achievements in immigration's eyes. Self-sponsored, they are, as we mentioned, they are self-sponsored. You don't need your petitioner, your employer. You don't need to have an employer for this. The employer doesn't have to pay for the application. It gives you a lot of flexibility to file your own application, you know, without getting an employer involved. But at the end of the day, you do have to show what your endeavor is going to be, and having a job is a good way to do that. But it's not required. You do have to show, for instance, if you're a PhD student or a postdoc, you know, how you're going to continue your research. You can even have self-employment and startups, and they're usually very good cases for national interest waivers, because for the regular labor certification process, applicants cannot sponsor themselves, so they cannot use the labor certification process. So, you know, if they can show that their startup and self-employment is something that's in the national interest waiver, then the national interest waiver is a very good option to them. But generally, you're gonna have to show a little bit more than I just have a company, I have some skills, and I'm starting my company. You know, you'd have to show that you're significantly far in achieving what you intend to do. Otherwise, they're not going to think the endeavors in the national interest. So companies that have some level of funding, it doesn't have to have massive funding, but you should have some funding, business plan. These are for these type of business national interest waivers are very, very important. Changing research fields. You don't have to be in the exact fields, but you shouldn't be jumping from one to the other, because the national interest waiver is based on your research. But in engineering fields, many of them are very closely aligned. You don't have to be in exactly the same field. But what we see quite a lot now is a lot of people changing from science to technology transfer, and that would be considered a major field change. So if you're a scientist and suddenly you want to you go into technology transfer, then it might be hard to justify national interest waiver based on your achievements. Okay, so just some key points. Backlogs for those born in China and India is for the NIW. So NIW does apply to Indians and Chinese, but there are more backlogs. So it's not any backlog than the PERM EB2 category. It's exactly the same EB2, so the backlogs are the same. As I showed in the chart, the backlogs are less acute, they're less long than they've been previously. I'm not sure how it's going to hold. So if those that have I-140s and national interest waivers already filed, or any EB2 already filed, they may want to think of applying for the adjustment of status now if they can. Again, no premium processing for NIWs, which means 9 to 12 months at least you're looking for adjudication. And in fact, many Chinese and Indian-born, do an NIW, just establish a priority date, get a place in the line, and then try to build up the EB1 case, which is much harder, because what happens is you can transfer a priority date from one category to another. So if you have very old or even get a new NIW priority date, if you build yourself up, you might be able to qualify for an EB1 case in the future. And then just especially those that are from India and China applying for NIWs, and they're on F1s or J1s, you just have to be careful because of the long wait. Going and getting a renewal of an F1 and J1 can be very tricky, because filing an immigrant petition shows immigrant intent, and F1 and J1s you're required to have non-immigrant intent, which means to go home after the program. Okay, so that's the national interest waiver. The other main one I want to focus on is the EB1A, which is alien of extraordinary ability. The way it works is as follows. You either have to have a one-type achievement, which means a major international award. Generally, those awards could be Emmy Awards, Academy Awards for sure, Nobel Prizes, but it doesn't have to be as high as that, but it has to be a very significant award. It's not merely just a lesser national, international award, which is one of the criteria we will see. So if you don't have this one-time achievement, then you have to meet 3 out of 10 criteria, and we're going to see what those criteria are. And you have to meet them in a very objective way, and we'll see what that means. And then the final merits. So once you've either got a one-time achievement or 3 out of the 10 criteria, then immigration is going to have a final merits determination. They're going to look and see, you've met the threshold. Now, are you extraordinary? And it's really that subjective, which gives them a very lot of leeway to make a lot of decisions. And this is, one of the reasons why this is a very difficult category to be approved in. So basically you have your threshold. For most people, you're gonna have your threshold, 3 out of 10 criteria, and then a final merits determination. I think it's important to define the field at the very outside of your case. If you're working in a very small field and you're a big fish in a small pond, so to say, that's certainly a lot better than being a bigger fish in an even bigger pond. So you want to see, are you extraordinary in your field? It can be self-petitioned, it can be employer-sponsored. The self-petition is the subject of this webinar, which means it's a very good option, for those that, for whatever reason can't have the employer sponsor them. The O1 visa is a very similar temporary visa. A lot of people feel that if you get an O1 visa, although it's very similar in the law, and it is almost identical in the law, except for the arts and in film and television, that you may qualify for an EB1 automatically, but that's not the case. In reality, even the O1, even similar, even the same law has a much tougher standard. Okay, so just looking at the criteria very quickly, and as I mentioned before, you have to meet these criteria objectively. In other words, it's not really a subjective. You can't play in with the criteria. So, for instance, the first one is a lesser nationally or internationally recognized prize or award for excellence in the field. So it has to be a national and international award. It cannot be a local award. Must be a prize. Immigration's view is that a prize or award doesn't mean a grant. A grant is not considered a prize or award. A grant is usually considered funding, or or a reward for work done, but that's not quite a competition in their words. Membership in associations that require outstanding achievements. This does not being just paying your membership dues and being a member in an association. They're looking for memberships that are selected, memberships where you're selected based on your achievements. For instance, the Academy of Arts and Sciences, those kind of organizations. Some associations have different levels of membership, where the lowest one is payment of dues, and then they have different membership requirements. So for those it depends on the membership requirements. If they are tough to get in, if they require outstanding achievements, then you could use those for this criteria. Publish material about the applicant. This is, generally press. 2 points. Number one, it has to be about the applicant in immigration's eyes. What does that mean? It, can it just be a mention or just the, even just the citation of research at the bottom of an article that doesn't mention the person. It really has to be about the person. So about the person, about the person's work, etc. And it has to be in major media. So it has to be in major publications in the field. Participation of a judge. This could be, this could be a jury for, artistic exhibitions, awards. It could be reviewing work of peers, editorial boards, things like that. And then original scientific contributions of major significance. It has to be original and it has to be of major significance. So they look into that. Patents, for instance, only talk to originality. They don't show that show major significance. This is usually where reference letters come in, but the government really wants to see more than just reference letters. They want to see contracts or press or something to show that your contributions are major in the field. Authorship of scholarly articles in major media and publications. So these are your publications, but it could also be a businessman in Forbes or Wall Street Journal, something like that. Display in the work in the field at artistic exhibitions or showcases. This criteria is really only for those in the arts. It's not for the sciences. Critical role or essential capacity for organizations with distinguished reputations. So these are organizations that are very distinguished. And the main point is you have to show that it's a leading or critical role. What immigration wants to see at the moment is that they are critical for the whole organization. So it's not really in the regulations, and we've argued against that in the past, but that's, if you look at all the requests for evidence, they always ask you to show how you're helping the organization as a whole, not merely your department. High salary in relation to others. There's certain government, Department of Labor manuals that show what the top 10% is, for instance. So you have to be above that. And then commercial success is again only for the performing arts, box office, things like that. One of the options you do have is what's called comparable evidence. For instance, if an application, for instance, well, let's say for instance, scientists, they don't present their work at artistic exhibitions as we saw. So we can argue that this doesn't apply to scientists, for instance, and the comparable evidence for that would be presenting in conferences. Again, you would still have to show that these conferences, are distinguished. Okay, so those are the criteria, and then once you've met 3 of the criteria, then you go into the incredibly subjective, final merits. Are you extraordinary? So they'll look at all of the evidence, and at this point, they will look and they said, technically, for instance, if a person has reviewed 1 manuscript, authored 1 article, and got 1 lesser-known national award, then they've met all 3 criteria. So they want to kind of avoid that situation, but so they do look at it and says, well, does this mean that, does the evidence show that you met the 3 criteria? Does that show that you are one of the very small percentage at the top of the field? And then, as I mentioned before, it's one of the toughest categories. It probably is the toughest category. It's a lot of requests for evidence, the dreaded RFEs. They're very uncommon. Sometimes, they don't even read the application. They're inaccurate statements. So it's very, very important to just, check them very, very quickly and thoroughly. And, one of the major complaints that we see is that, immigration seems to be very against reference letters at this point for this application. So if you have an application that's really based only on reference letters, immigration just feels that it's likely that people who know you and like you are going to write good things about you, and generally that's just one of the things you want to try and get as much objective evidence as you want. So for instance, you want to look at citations. Citations for EB1A as opposed to EB1B, which is a sponsored application, is much higher. They really want to see more than 1,000 citations, which is very, very high. But sometimes they're, we've seen cases, with lower citations, but you really need something else to make up for the low citations. Oh, oops. Okay. Okay, so that's the EB1As. So if you looked at the National Interest Waiver, the EB1A as your self-sponsored, and then you've got the EB5 immigrant investor. I don't want to spend too much time because this is a whole webinar in itself. But it's a self-sponsored application. And, you don't need a petitioner, an employer for these. So I just did want to mention them. Really, what they are job creation programs for U.S. workers, and that have an immigration benefit. So you get the green card for creating jobs in the U.S. The number of the investment, the amount of the investment has increased recently. It's now 900 to 1.8 million, depending on the location of the business. If location is in a targeted area for unemployment, then it's going to be 900. Otherwise, you're looking at double that, 1.8 million. So that pretty much puts it out of a lot of the reach of a lot of people, but there are many people that still file these and can meet that. You have to create 10 full-time jobs. It doesn't include the investor or the family. There are two types of application. One is called, investing in your own business. And that's actually only 10% of the EB5 cases. And then there's what's called a regional center investment, which more than 90% of the applications are in the regional center. And what's the difference is the investing in your own business is really what it sounds like. For instance, you're in a targeted area, invest 900 in 900,000 in that business, and you create 10 full-time jobs, and that's your basis for immigrating. What you have done. But you can see, having 10 full-time jobs and having, investing 900K in that, it doesn't really go very far. You're probably going to have to invest a lot more than that to have a business with 10 full-time jobs in many places in the country. So most for this reason and for other reasons, the regional center is essentially an entity that has been approved by immigration to accept investments. So essentially what happens is you're investing in somebody else's company. So you don't have to manage it. They've got very good economic plans that show how each investment is going to create 10 jobs, et cetera, et cetera. So most, as I said, about 90% of all EB5s go into these regional centers. You always have to show that the money is lawfully earned, it's tax transferred, et cetera, that it's sourced in a legal manner. And due diligence on EB5 projects, especially the regional centers, and there are lots of them, there are hundreds of them, is very critical because especially when you're investing in somebody else's company, you just want to make sure that you check out the investment model and make sure you're happy with that. Okay, and then Green Card Lottery, it's one of the programs that is perpetually on the chopping block, but right now, it's just been announced that it will be going ahead this year. There are 50,000 green cards, and about 10 million apply. There are 100,000 winners. Now, those 50,000 green cards includes the family of the winners. So if you do the math, you'll see that there are 50,000 green cards for 100,000 winners plus their family. So what typically happens, even if you're a winner, it doesn't mean that you've won. It doesn't mean you get the green card. It just means you're eligible to apply, and it's kind of a race. It's based on priority dates, or systems similar to priority dates, where certain countries that are less represented in the U.S. have greater chances of winning. It's based on a country of birth, again, not on citizenship. There are lots of countries that that have a lot of representation in the United States, so they're not eligible to apply. And then they are cross-charge. There's a cross-charge, and this applies actually to all EB, all EB applicants or applications or employment-based applications. That if you're born in, say, India or China, and you're married to somebody that's not from India and China, essentially for immigration purpose, you are born in the country of your spouse. So if you have a spouse born in another country, then you can jump the line and go with everybody else, the non-Indian and non-Chinese born people that are able to apply earlier. Just with Green Card Lottery, if you not from one of the countries excluded, essentially it's a lottery. There's no reason not to do it. You should definitely do it. Just like you wouldn't base your monetary strategies of earning money and financial strategies on a lottery, on taking a ticket in a lottery, you probably shouldn't do that for immigration either, but it's certainly something that could have benefit if you win, so there's nothing to lose. And then just finally, in terms of family-based green cards that don't require sponsorship, the main one is immediate relative because it's the quickest. If you're a spouse, parent, minor child means under 21 of a US citizen, you can have your relative apply for you. They are always current, so you always get the work permit and travel document within 6 months. Currently, the actual processing is a little slow due to the pandemic. 12 months is kind of normal. If you're married to a US citizen, you only get a 2-year green card, and you have to show that the marriage is still continuing after those 2 years. And then a child, to apply for their parent, must be 21 years old. I get a lot of cases, oh, I've just had a child, a baby who's a US citizen, can my child apply for me? And unfortunately, the answer is yes, but they have to be 21 first. Okay, and then just in terms of family-based, just for the non-immediate relatives, there are other categories for non-immediate relatives, but they're very backlogged. So you can see unmarried adult children of U.S. citizens, 6 to 7 year backlog, spouse, children of legal permanent residents. That's actually current at the moment. So when it says 1 year, it's really 1 year is kind of it's like the immediate relative. That's how long it takes to adjudicate the application, not the backlog based on the quota. Unmarried adult children, 5 or 6 years. Married adult children of U.S. citizens, about 12 years. Brothers and sisters of U.S. citizens, 14 years. And then if, you know, the Mexican and Filipino-born folks are like the Indian and the Chinese for the employment base, and those are much, much longer. And then just my final point is just a quick run through of the actual immigration adjustment of status. Right now, what we've done are all the categories in terms of the basis for immigration. Adjustment of status is just it's certainly a webinar in itself, and that a lot of this will be the subject of the webinar tomorrow with my partner Bernie Wolfsdorf. But this is your actual immigration. And the kind of things that they're looking for are as follows: checking for identity. So you know, we can see birth certificates. Indian birth certificates is an issue. If you're from India, make sure you have a birth certificate. If not, you might have to get affidavits to corroborate your birth. Sometimes birth certificates are incomplete. They don't have the name. They don't have the date of birth. Sometimes they're registered later, and you have to explain why they were registered later. So that's part of checking for identity. You can have biometrics for criminal records checks to make sure you don't have a criminal record. Certain criminal records will make you inadmissible to the United States, but some not. They're going to check your immigration violations, if you have or if you have not. So you must make sure you've always maintained your status. There might be certain limitations to that, certain exceptions, and you're going to have a medical to show you have the required vaccines. You don't have any communicable diseases that are interested to the CDC, that the CDC is interested in. Public charge is one of the main issues that they're looking at the moment. It's been going back and forth in the courts whether they can actually check into this or how much they can check into this, but it seems that the courts finally sided with the government, and their rule is going you know, as planned. So you have to check any public benefits that you've had or likely to take if you're not employed, for instance. So public charge is an issue that comes up at this stage. Criminal records we mentioned. Generally, a GUI is, you know, it's not that problematic as long as it's just one DUI and it's not it's a simple DUI. You know, no manslaughter or anything else that comes with it. But criminal records, each criminal record has to be looked at, and could, you know, certain crimes will make you inadmissible, others not. Maintaining your status, make sure you always maintain your status from the time that you're, from the time that you enter the United States until you actually get the green card in hand. Medical issues we mentioned. Dependents can apply with the principal applicant. That includes the spouse and children under 21. So, you know, for those that have been waiting a long time, especially those in backlogs, you have to make sure that there's enough time that your children don't, quote unquote, age out when they turn over 21 before you can get through the process You know, so you know, then they cease to be your children for immigration purposes. So it's extremely important to plan ahead, so that you know your children can apply with you and are not separated by virtue of them turning 21 during the process. As I mentioned before, work permits and travel permits only come with this application. They're currently taking around about 180 days to get. Some are taking quicker. So I've actually seen somewhere between 2 and 6 months is currently there. With the pandemic, they're a little bit inconsistent in their adjudication times. And then all cases currently have to be interviewed. This is generally what happens in the United States. Right now, for those that are applying for this final stage abroad, you know, unless you meet certain exceptions, you will, there's actually a travel ban until the end of the year of these applications. And that, in a nutshell, is the webinar on self-sponsored green cards. We have recorded this webinar, and you'll be able to see this online on a YouTube page. Otherwise, my contact details are there. Feel free to reach out to me if you have any questions. We'll now go to questions, Q&A. If you have a question, feel free to put it in the Q&A box, and we will answer them until 1 o'clock. And then any other questions after that, feel free to email me directly. So I'm just going to read them straight. So I've not had a chance to edit them or read them beforehand. So, okay. I would like to know if this adjustment of status happens between the EBX to the green card. Is this when the steps fits the process? So what happens is the EB, as we say, is your basis for immigration. That's going to be first always. If your application is current, then you can file what some people call the green card, the adjustment of status application at the same time. But if you're not current, then you have to wait until your place in the line is before you get to the adjustment of status application. So what happens between the two? Essentially, you're in the same position as you were before that application has been filed, which means if you're on H-1B, you have to make sure your H-1B is current, O-1J, whatever your visa is, until you're able to file that, you have to make sure that you are current. Okay. Is the I-140, if the I-140 is applied and was approved for a previous employer and the current employer has not yet filed, do we apply for I-140 once again to try and downgrade from EB and try to downgrade from EB2 to EB3? So this is a very good question. I've had this question a lot on the EB2, EB3 based on the visa bulletin. So if you have an employer that files an I-140, a basis for immigration, and they file, let's say, a while back, and say they file in 2014, then what happens is the person, left the employer, and now it's with a new employer, and suddenly, as happens now, they can file the I-45 because miraculously and unexpectedly, what happened was that the EB2 let's say for India, the EB2 is now current for filing. So what happens is that in order to do that, you need to at least have an I-140 approved for the employer that you're with now, or it could be that if you can go back to the previous employer, that would work as well. But the I-140 that is approved has to relate to the employer. You have to have the job that you're going to apply based on that. So what you would have to do is you'd have to get a new I-140 with the new employer in order to benefit from this situation. You cannot benefit from an employer-based I-140 without having a job for that person. So it's very attractive to file the I-45 now, but you're probably going to have to wait. Okay, I'm on an H-1B and was laid off. Can I clarify if I need to either switch my status or leave the US with 60 days of my position ending? What happens if I stay over 60 days due to COVID? Limited flights are trying to apply for jobs. Okay, so somebody's on an H-1B and who's laid off. Generally, if they have 60 days left on their petition on the date that they were laid off, then they have a 60-day grace period. So they can change their status in the United States, or they can leave, pack up their things and leave during that time. If you can't leave during that time, then you're going to have a violation of your status. Depending on how long you overstay, will depend on the consequences. You know, if it's because of COVID, you might have a good reason for them to adjudicate a future visa application, whether immigrant visa or non-immigrant visa, in your favor. It's, you know, it's discretionary, but it's not it's not something you can bank on. So certainly, if you can't leave within the 60-day grace period and you haven't found a job, you're kind of stuck. It's better. It would be better to do everything you can to leave during that time. Okay. For national interest waiver, if I have a master's with presentations and some research, can it be applicable, or is it more for PhDs? So it's a good question. It's certainly a PhD, you know, when you're dealing with subjective cases, you know, having a PhD is very strong. But certainly, you know, if somebody has a master's degree and they have some good research, some good citations, good publications, then then that is certainly the basis of a good national interest waiver case. It's less based on the degree than on the research and the accomplishments of the person. So I would say certainly it's something you should consider. Any advice for freelancers in advertising, film, post-production, animation, VFX, and the arts? So when you come to the arts, unless you have a really good angle how your work is in the U.S. national interest, you're really looking at alien of extraordinary ability. I mean, some can show national interest. For instance, if you're in the you know, if you're in a museum, or you're doing something that we can show in the national interest, but generally it's going to be EB1A. And EB1A for freelancers means that you're going to have the tough standard. So any advice? Certainly make sure your profile is as strong as possible. Get out there. Make sure you get as much press as you can and awards as you can, and don't be shy and bashful, and be able to promote yourself. I'm on an H-1B and would like to try for the national interest waiver. Is there a grace period to stay in the country if there is a long wait? So what happens is, if you're on an H-1B, you can definitely file for the national interest waiver. If you're not born in China and India, then it's a very good option. You can file at this point the I-140, the national interest waiver, and you can file the adjustment of status together. So there's no issue with staying in the United States, you know, probably even if you lost your job. But if you're Indian and Chinese, then you have to make sure that that H-1B is valid until such time that at least you file that I-485 application, that adjustment of status application, which means you have to, the H-1B does have 6 years of H-1B, and then you cap out. But if you filed that national interest waiver 1 year before your 6-year cap, then you can keep extending that H-1B beyond the 6-year maximum. Likewise, if it's pending for less than 1 year, and the national interest waiver is approved, and your application is backlogged, then you can still extend your H-1B. So there are other options, O1, J1, there are different options, but certainly if there's a long wait, you have to keep your status current. In your experience, which category or reference letters considered more probative? The extraordinary ability or the national interest waiver? So definitely in the national interest waiver. National interest waiver, they really want to see the letters just to show two things. Number, what you're going to do. Why is it in the national interest? Number one. And then number two, just to show why, how you've impacted your field. So in that second one, it's less probative as in the first one, but generally reference letters are much more accepted in the national interest context. Okay, so I will do one more question. I'm sorry I wasn't able to get to all of them. One more question, and then if your question hasn't been answered, feel free to email me. I'm happy to answer it personally. When a national interest waiver package has been filed and an AOS is filed concurrently, if later the non-immigrant petition expires and cannot be renewed before the AOS is approved, will USCIS still grant the AOS on the person working on an EAD only? So the answer is yes. There are two alternate. As long as you keep your status until the AOS, the adjustment of status, is filed, and you don't have more than 6 months of unlawful presence or lawful work authorization or no work authorization, then you can still adjust status. So you just have to be careful. Filing the AOS is not in itself enough. You still have to wait for the EAD, which can take 6 months. So certainly if you kept your status until the adjustment of status was filed and then waited to work until you got the EAD, that would be sufficient under the current immigration program. So thank you very much. I've really enjoyed the webinar. The questions were good questions, and looking forward for everybody to come back tomorrow for the next webinar. Thank you very much.